you doing? Hope you are good. Hope you're fine. Hello. You're welcome to Lawyers Infohub. It's a platform we share law tips, legal tips for students, lawyers, to help you become knowledgeable, to help you become more knowledgeable too, and also help you in your career, in your work, and in all you do as a lawyer. You're welcome. If you're a returning subscriber, thank you for always stopping by to know what is new. And if you're you who is new, please do hit the subscribe button. Now, we're looking at the extrajudicial statement of an accused person. When a person is arrested, taken to custody, the first thing they usually do is to get the statement of that person, be it in the police, be it in EFCC or any other organization that has the power to arrest. So making of a statement is part of investigation. So the first have the person make a statement, then they will proceed with their investigation. Now, that statement is a crucial document that is used by the prosecution in a criminal matter. Now, the manner in which it is obtained is another thing, and the voluntariness of that statement is also another thing. It's also important to note that from a statement, you know whether it is an ordinary statement or a confessional statement. Now, an accused can make an ordinary statement, which is a statement that indicts other people, you know, to the commission of a crime, while a confessional statement is that statement wherein the accused person admits to the commission of the offense. Now when is a confessional statement, it has effect of a plea of guilty. Now, you must understand that the courts have always regarded extrajudicial confession properly proved and admitted as having the same effect as a plea of guilt by the accused. Now, in as much as a person has pleaded to the commission of a crime, you know, they it does not relieve the prosecution of its duty, to still prove beyond reasonable doubt. Because the prosecution will now rely on the confessional statement of that accused to prove their case. It is also the right of an accused person to remain silent from the point of arrest, investigation, trial. You can choose not to say anything. It's a constitutional provision. But at the same time, if you choose not to say anything, you can't complain that your right to fair hearing has been breached. The police, has a role to play in terms of ensuring that the statement elicited from an accused person complies with the laid down principle and the law. In as much as the police has discretion on how to conduct that investigation and all of that, but there are laid down rules they must also, they must, you know, always, abide with. Eliciting of a statement should be devoid of duress, indictment, threat. You know, it should be elicited without any form of inducement, any form of threat to life, torture. So now, the Evidence Act section 29 2 and 5, makes provisions for issues of statements, how it was obtained, if it's obtained by through oppression, you know, if it's whether the admissibility. So the Evidence Act, in considering it at section 29 sub 2, said if in any proceeding where the prosecution proposed to give in evidence a confession made by a defendant, it is represented to the court that the confession was or may have been obtained by oppression of the person who made it, or in consequence of anything said or done which was likely in the circumstances existing at that time to render unreliable any confession which might be made in such a consequence. The court shall not allow the confession to be given evidence against him, except insofar as the prosecution proves to the court beyond reasonable doubt that the confession was not obtained in a manner contrary to the provisions of this section. That is to say that where a defendant or accused person can prove, like to the court, that this statement was obtained in a manner in which it was not supposed to be obtained, the court will not allow the prosecution putting it in. That is why the court will not allow the prosecution put it in. That is why at that instance, a trial within trial cannot, be done to ascertain the voluntariness of that statement. Now, in TOP and Aloze, which is the 2017 7 Nigerian Weekly Law Report, Part 1565, 368 to 389, the Supreme Court held that courts are bound to reject an accused person's confession, which was elicited through torture, duress, threat, or inducement. So if you're handling a matter and your client is insisting and saying that my statement was not voluntary, it was not something I gave, you know, was not something I gave voluntarily, then issue of trial within trial can come to terms and will not come to play. You know, wherein the parties, wherein the parties, wherein the parties will now, confirm or ascertain how it was elicited. It's very important, trial within trial. Now, the ACJL, that's the Administration of Criminal Law Justice Law of Lagos State. Many states have also, have incorporated this law into their own laws. They have also domesticated it. The court has held, and it is the provisions of the ACJL that if after the prosecution has put in their documents and their proof of evidence, and they are calling in, they want to bring in additional confessional statement or notice to file a notice of additional evidence that the court, you know, and that additional evidence is not like an additional statement of the accused. The court will reject it because it assumes like, where was this evidence before? Are you just bringing it as additional evidence? Where was it before? So it does not connote the statement of accused. So if such thing happens, you can bring an objection. Is it an afterthought? Is it an aftermath? Where is this evidence coming from? Because it was supposed to be part of the proof of evidence. It's also important to know that an accused person's extrajudicial statement is only evidence of the fact that it was made, but not necessarily the evidence of the truth of its content. The fact that someone said, I didn't do it, or it doesn't mean, it has to be proved. So it's just an evidence of the fact that something was made, but it's not an exclusive proof of the truth of its contents. So you must also understand that when an ordinary or extrajudicial statement becomes a confessional statement, by definition of confession, Section 28 of the Evidence Act defined, a confession as an admission that is made by a person charged with a crime, stating or suggesting the inference that he committed the offense. So a confessional statement, as earlier said, is that statement where the accused person is saying, I did this thing, or admits to the commission of the crime. So that's the definition given to you by Section 28 of the Evidence Act. Now, for there to be a confessional statement, the admission of this person, of this accused person, must admit to the elements of the offense. It must admit to the elements of the offense. It must not be half and half. It must not be admitted to just a part of it and is rejecting a part of it. So confession, it must be cogent, it must be all-inclusive. Now, in Okalawon against the state is a 2015-17 Nigerian Weekly Law Report, Part 1489, 445 Supreme Court. The Supreme Court held that for a confession to be, that a confession to be a criminal suspect's oral and written acknowledgement of guilt. So it is that accused person acknowledgement of guilt. Yes, I did it. I'm the one. Acknowledgement of guilt often includes the details of the crime alleged. So a confessional statement or a confession is the acknowledgement of guilt or the acknowledgement of the commission of a crime by an accused person. Now, for that extrajudicial statement to constitute a confession, the maker must acknowledge that he committed the crime uh, for which he was arrested and charged. The admission must be clear, concise, and unequivocal. He must not say, I did not hear, and tomorrow he said, I did not. It must be unequivocal. Now, the confession must be voluntary, it must be direct, it must be positive, and unequivocal. It must be voluntary, it must not be forced to do it. It must be direct, it must be positive, it must be true, and unequivocal. Now, confessional statements are only admissible in court against the maker, that is the accused person. It must not be for another person, for the maker, admitting to the commission of the crime. Now, it's important that the court gives holistic construction of a confessional statement. In giving meaning to the court must give the statement a holistic analysis and holistic construction. Court should not pick here and leave out, must look at it holistically. Now, where a statement of an accused person is now adducing defense or that the person is innocent, is no more a confessional statement. Now, the court will have to critically look at it. Is this person saying, this is the reason why I did this? Or this person saying, I am innocent of whatever I'm being accused? It's no more a confessional statement. So for a confessional statement to be utilized by the court, it must be positive, it must be true, it must be direct, it must be unequivocal of the facts. To satisfy the ingredients of that offense. It proves the guilt of an accused. A confessional statement does not provide defense or the innocence of an accused person. It proves the guilt. So whenever a confessional statement, your client gives you a confessional statement, or you read with respect to your client's case, this is his confessional statement. I look at it, the content shows defense, it shows denial. It is no more a confessional statement. So these are the things you have to look out for when you are being given a statement of your client or in a matter you're handling. Say this is the person's confessional statement. Another thing you have to know that the confession must relate to the offense charge. If the person is charged for armed robbery and what the person's confession is just robbery, then it's no more a confessional statement. It must relate to the offense charge. They know that the crime in the confession must be the crime for which the accused is charged with. Check out the case of Badamosi against the state. It's the 1992 Nigerian Weekly Law Report, part 266465. There are other cases you have to look at. You can look at Fadeli against the state. It's also a 2015 12th Nigerian Weekly Law Report, part 1472 and 63. So these are cases that deal with confessional statements. These are cases that deal with confessional statements, so that if what the person has confessed to does not relate to offense charged, so you can take up a preliminary objection on that part, or these are things you will consider in maybe your no case submission if you are towing the line of no case submission. So is the confessional statement direct? Is it true? Is it unequivocal? Does it relate to the offense for which the person is charged? Now, there's nothing like anticipatory or preemptory confession. When somebody is confessing to something that's yet to happen, there's nothing like that. A man cannot confess to a crime that is yet to happen. So there's nothing like anticipatory or preemptory confession. There's nothing like that. It is a confession as to what has happened and not what is to happen or what is about to happen. So these are things to look at. So if you look at the evidence or the confession, it's talking about something, and these people are planning to do this. This plan is for so and so. Then it becomes a preemptory confession and no more a confession as it ought to be. Now, there are some key points you have to note on principles on extrajudicial confessional statements. Now, when there's an omission in an essential ingredient in the offense charged, it cannot be cured by confession of the accused. So, an omission on an essential ingredient in an offense charged cannot be cured by confession of the accused. can check out the case of Abasi against the state, the 1992 8th Nigerian Wiki Law Report, Part 260. Then a confession is relevant fact against the maker alone, not against his co-accused. Unless the co-accused now adopts holistically that is the confession of that other person by words, by conduct. Now, an accused person who makes a confessional statement or pleads guilty to the charge would appear to have extinguished the preemption of what innocence that accused to him by his right under the to him again because he has pleaded to the commission of that crime or to that or charge or that offense. So now a court can convict on the extrajudicial confession of an accused person, which is voluntary, true, but inconsistent with his evidence in court. Sometimes when these people, when some people say an accused person is being arrested and maybe confess to the crime, and subsequently in course of trial they will deny it. So in this instance, the court can convict on this extrajudicial confession, which is voluntary and true, but is now inconsistent with the evidence in court. So in that instance, the court will use its discretion to look at it holistically. Now, when an accused person gives two confessions, and the court will likely look at the first one and sees the second one as an afterthought, because the second one would have been he has thought through and think, how do I escape this? So in that instance, the court will look at will always tilt to the first confession given. The effect of a confession is to make the burden of proof on the prosecution very light. So once there's the confessional statement, the burden on the prosecution it becomes very light and more like a feather of an ostrich. So once there's a confessional statement, the burden on the prosecution is reduced, and I would say that of the defense becomes tough because the person has alluded to the commission of the crime. But the question now is the confession true? Is it cogent? Is it unequivocal? Is it direct? Does it relate to the offense charge? So these are many more the things you consider as a counsel, hand in this in a criminal matter. These are things you have to consider, whether you are for the prosecution and whether you are for the defense. It's important to look out for section 28 to section 32 of the Evidence Act. It deals on confession admission. So you can't be vast in your criminal law proceedings without having to read these sections of the Evidence Act. So we'll be able to look at extrajudicial statement, what makes it confessional, that there is ordinary statement and there is confessional statement. If it's confessional statement, what should it contain? So at that instance, the court still overlook a confessional statement. At that instance, the court will, despite a confessional statement that is inconsistent with the evidence, what can the court do? So we'll be able to look at it and some of the principles that allude to extrajudicial statements. I just hope you'll be able to learn something today. And if you have your questions, just drop them on the comment section. It will be attended to. Thank you very much and do have a great time. This